Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, the managing partner of Hull & Hull, a firm specializing in estate, trust, and capacity litigation. I'm very pleased to be joined today with counsel to our firm, David Freedman, and our co-founding partner, Ian Hull. David, incidentally, is also the director of the Elder Law Clinic at Queen's University, and he's an unbelievable social media icon out there, leading the Canadian Estates and Trust Litigation Council blog. So we are very lucky to have David with us today. Ian, we hear so much in the news these days about this intersection between estates law and family law. And there's this whole conception out there that when someone dies, their estate's automatically going to go to their surviving spouse, or if there's an issue, it'll be divided in some random fashion. What exactly is some of the background to the Family Law Act?
Well, I think it's a really good starting point to what is a fundamental, probably misunderstanding with a lot of our clients. In that there's sort of two acts at play, the Family Law Act, and we'll talk about later the Succession Law Reform Act. But the Family Law Act does govern how an estate may be distributed on death as between spouses, and notwithstanding the provisions of your will.
And I think that's the key, notwithstanding the provisions of this will that you may have created otherwise. David, can you tell us a little bit about what the Family Law Act here in Ontario provides?
Sure. Actually, this is a really interesting area because, before there was family law, it was all estates law. And that's how families were provided for in common law doctrines. And for a long time, that kind of worked. And then eventually we had to reform our law. And now we have a really, really strong regime of family law in Ontario. And so one of the interesting things is that a spouse, a married spouse, whose partner dies, can treat the death of that spouse as a separation under the Family Law Act. And if there are, absent domestic contracts, absent special circumstances, it guarantees a spouse to be treated at least as fairly on the death of his or her partner as if it was a separation. And that's important because if the will doesn't provide enough to that spouse, then they can seek a remedy under the Family Law Act, and we call that an equalization election, and they can just plead their rights under the Family Law Act and get what would be due to them on the same as on a separation.
Susanna, what do you do about this equalization, though? How do we manage that issue in our practice?
Well, that's an interesting one that we come across, and that really requires someone who's knowledgeable in terms of doing that calculation, because the idea is to share the growth in the family relationship during the tenure of that family relationship in assets of respective spouses. So if there has been a growth in favor of the husband, for instance, 1/2 of that is going to be split and left with the wife.
And I think we see, David, in your practice too, because not only do you teach to the students, you also teach to your clients and have a busy private practice, that dynamic of the calculation can be difficult because there are intricate rules tied to what gets put on one side of the husband's side and what gets put on one side of the wife's side, and we're always battling away to try to make it obviously whatever side we're advocating for.
And the difficulty is if these things were not thought about when somebody drew their will, because there's one way to handle it works very well, and that's insurance. And if it's been thought out in advance, you can plan against an equalization election, particularly if it's a second or a third relationship. And there are a lot of people to be considered, and the circumstances are a bit complex. But as you say, after the fact, coming up with the right numbers and the right valuations can be a difficult process.
But I think that's such a good point, and really one that I think sinks in with a lot of clients is that, and although we don't sell the product, the insurance solution can smooth a lot of the round edges on any marriage breakdown, on death, in the same way that it would be in separation, in the sense that you can allocate the insurance to the surviving, both if they're both surviving. But when you have a death in the family, that is a great rounding error tool that a lot of people sort of underestimate the simplicity of it. And also at the other end of the day, it allows lawyers flexibility and avoids little niggling fights over things when we can place and allocate properly the funding.
Yeah, absolutely. For these property type things, I think insurance is good. The only problem is where it doesn't really work so well is where there are support obligations that still have to be respected after death, and that's a different story.
And the whole Family Law Act regime really applies, as you said at the outset, David, to married spouses. And given the statistics here, certainly in Canada, and the fact that most people are actually in non-married kind of relationships, that brings us into this other area of legislation, the Succession Law Reform Act. Ian, can you tell us a little bit about how that act comes about in our daily practice?
Well, I think the two things, and both of you just made the point. One is ongoing support obligations. How do we manage that? Because we have someone dead. And so we have lost an income stream or a source of support payments in that sense. And the other is a non-married spouse. So the Succession Law Reform Act accommodates both of those problems. It addresses common law relationships or spousal relationships that are not married. And it addresses how the estate is expected to fund what is an ongoing support law obligation, whether you like it or not.
Right. So that the difference between the two regimes, of course, is when somebody's alive, they're generating income and they can meet support obligations. And we have great guidelines, for example, for child support obligations that allows a parent to know, how much child support that they have to pay. After death, we no longer have an income earner, but we do have property, and that property may continue to earn income, but it's very difficult then to apportion from the fixed sum that you have available in the estate as to who gets what. But the law can do some really interesting things, like bring back into the estate assets that would not be there just to satisfy the support obligations, because you can't disinherit people that you're obligated to support or can't not provide for them.
And I'm sure both of you have heard, as I do all the time, then, people say, well, then what exactly is the point of a will? Given that we have legislation that will change the estate plan if the individual chooses to pursue that, what exactly do you say to your clients when you're trying to advocate the importance of a will nonetheless?
Well, first of all, I like the uncertainty of wills. And it's for a couple of reasons. One is that not all of the best decisions are made at the time you make your will. Big mistakes can be made, and they can be driven by emotion or just a lack of knowledge or errors in understanding obligations and so on. So wills shouldn't be treated as the only document that matters on someone's death. So the fact that we have legislation that sort of plays with wills is a good thing from a policy standpoint. But I'm also not afraid of saying at the same time to clients, most wills do go through the system like a hot knife through butter. You do not see, a high percentage, certainly in my practice, I would say over 90% of wills just simply go run of the mill, and they don't see the light of day in any contentious way, and they don't get tinkered with in any contentious way. So you're winning a bit of the lottery there on that side.
I would say the only wrinkle on that is the one that you brought up, and that is the cohabitational spouse. And, all of the family law protections are premised upon a marriage. And in society, I don't know if there is a difference anymore between a non-married couple and a married couple. But in law, for the purposes of property division, there's a big difference, and the way to remedy that may have to be through the dependent support claim process under Part 5 of the Succession Law Reform Act.
Well, thank you very much, David, and thank you, Ian. And thank you for joining us here at Hull & Hull TV.